Hold onto your LLCs. A hidden storm's brewing, threatening to hit American business owners with a $500 daily penalty. But fear not, knowledge is power. Get ready as we crack open this mystery, reveal the truth, and legally sidestep this financial typhoon. Pens and paper at the ready. Let's navigate this together. Understanding the Corporate Transparency Act. The Corporate Transparency Act, which came into effect on January 1st, 2024, has marked a significant shift in the regulatory landscape for businesses, particularly those structured as limited liability companies, LLCs, or other state-formed entities. This legislative development brings about a pivotal change by mandating increased transparency in corporate ownership information. The primary objective behind this regulation is to fortify measures against money laundering and illicit business activities. The government, under the provisions of this act, now requires businesses to furnish detailed information regarding their ownership structure, effectively creating a more comprehensive database for regulatory scrutiny. This choice arises as a direct reaction to escalating worries regarding the utilization of business entities in illicit financial practices, including money laundering and deceptive transactions. To address these concerns, the government is mandating companies to unveil details about their beneficial ownership. The objective is to establish a strong framework capable of identifying and addressing potential risks within the financial system. Consequently, the Corporate Transparency Act takes on a significant role in the broader battle against financial misconduct, empowering regulatory authorities with enhanced insight into business ownership structures and fostering a more comprehensive and effective monitoring system. While the Corporate Transparency Act is an admirable step toward improving financial integrity, it also presents challenges for businesses in terms of compliance and operational changes. Companies must now navigate the complexities of providing accurate and up-to-date ownership information to comply with the new regulations. This necessitates a reevaluation of internal processes and systems to ensure consistent adherence to transparency requirements. As businesses deal with these changes, the Corporate Transparency Act's broader impact on the corporate landscape has yet to be fully realized, shaping the future dynamics of how businesses operate and how regulatory bodies combat financial crime. The enactment of this legislation marks a significant shift in corporate transparency, as companies are now mandated to disclose crucial information about their beneficial owners. The era of utilizing limited liability companies, LLCs, as a shield for privacy is coming to an end, as this new act brings heightened scrutiny to ownership structures. The spotlight is particularly intense for individuals who hold more than 25% ownership stake in a company. This move is not merely a procedural change. It represents a pivotal moment in regulatory efforts to combat financial opacity and illicit activities. For years, the privacy shield provided by LLCs has been a double-edged sword, offering protection to business owners, but also facilitating a lack of accountability. With the advent of this legislation, the dynamics are set to change, demanding greater accountability from those with significant ownership interests. The move towards transparency is driven by a collective push for fairness, integrity, and ethical business practices. As a result, companies must now navigate a new landscape where disclosure is not just encouraged, but legally mandated. While the focus is on the corporate entities themselves, the ripple effects extend to various sectors, influencing legal, financial, and ethical considerations. Companies are compelled to revisit their ownership structures, reevaluate risk management strategies, and adapt to a new era of heightened regulatory oversight. This legislative development underscores the broader global trend towards increased transparency and accountability in corporate governance, signaling a commitment to foster a business environment that prioritizes openness and integrity. The penalties. The stakes have never been higher as a new regulation demands detailed personal information, and failure to comply could lead to severe consequences. Picture this: a whopping penalty of $500 per day for non-compliance. It's not just about the financial hit. The prospect of facing up to 2 years in jail and an additional $10,000 fine is enough to send shivers down anyone's spine. The gravity of the situation has people on edge, grappling with the anxiety of inadvertently crossing the line and facing the wrath of the law. The pressure to provide the required information is palpable, creating a sense of urgency and anxiety among individuals and businesses alike. The fear of falling afoul of these regulations looms large, prompting a scramble for compliance and a meticulous review of data protection protocols. This legal tightrope has everyone reevaluating their practices, from data collection to storage and disposal. The potential consequences are no laughing matter, and the specter of hefty fines and imprisonment has prompted a wave of concern across various sectors. Amidst this unpredictable environment, enterprises are tasked with maneuvering through a web of legal obligations, harmonizing adherence with safeguarding their concerns. The repercussions of non-compliance extend well beyond monetary fines, impacting not only financial aspects, but also tarnishing reputation and eroding trust. Against the backdrop of time ticking away, individuals and entities find themselves grappling with the delicate balance between the imperative for privacy and the escalating call for transparency. The specter of penalties hangs prominently, underscoring the vital significance of comprehending and conforming to the intricacies of the evolving regulatory landscape. How to avoid the $500 daily penalty legally. Starting your own business can be both exciting and intimidating. The allure of forming a limited liability company, LLC, to protect personal assets and reap tax benefits is a common story in the business world. However, there is a counter-argument that challenges this conventional wisdom. The key to avoiding legal entanglements, my friends, is the surprisingly simple advice of not forming any LLC at all. It may appear counterintuitive, but by deviating from the standard business structure, you may be avoiding potential pitfalls and unlocking a smoother path for your company. The objective is to dispel the misconception that establishing an LLC is obligatory when launching a business. Some assert that the process of creating an LLC might bring about more challenges than solutions. Although an LLC offers limited liability protection, navigating through the bureaucratic procedures can turn into a daunting task. Opting to sidestep the complexities of extensive paperwork, yearly filing obligations, and potential associated fees with running an LLC could be a prudent choice. This unique perspective urges prospective entrepreneurs to explore alternative business structures that align more effectively with their individual requirements, such as a sole proprietorship, partnership, or even a corporation. Moreover, not forming an LLC doesn't mean forsaking legal protection altogether. Entrepreneurs can still take steps to shield personal assets and mitigate risks without the complexities associated with an LLC. By understanding the nuances of business liability and seeking legal advice tailored to their specific situation, individuals can forge a legally sound path for their ventures. In essence, this alternative approach challenges the traditional narrative around LLC formation, offering a fresh perspective that empowers entrepreneurs to make informed decisions that align with their business goals and aspirations. Choosing the right business structure is a crucial decision for entrepreneurs, and the Limited Liability Company, LLC, has been a popular choice due to its flexibility and liability protection. However, as we approach the end of 2024, it's imperative for current LLC owners to reevaluate their structures. If the LLC is not providing the anticipated benefits or aligning with your business goals, there might be a compelling reason to consider dissolution before January 1st, 2025. This strategic move can potentially save you from unnecessary expenses and streamline your business structure for the upcoming year. Those deciding on their entrepreneurial journey should exercise caution before forming an LLC. Instead, consider other options that may be more appropriate for your specific situation. The advice goes beyond mere suggestion. A detailed guide on how to start a legitimate business without using an LLC in under 5 days will be provided. This alternative approach aims to help new entrepreneurs navigate the complexities of business formation, resulting in a smooth and efficient process that aligns with their business goals. In the ever-changing world of entrepreneurship, staying informed and adaptable is critical. The recommendation to reassess existing LLC structures or postpone new LLC formations is based on the recognition that each business is unique, and a one-size-fits-all approach is not always the best solution. This advice encourages a thoughtful and strategic approach to business formation by providing guidance on dissolving an LLC for those already on that path, as well as an alternative for newcomers, laying the groundwork for success in the dynamic business environment of 2025 and beyond. We've reached the end of this video. Remember, keeping it penalty-free at $500 a day is a breeze. Just bypass the LLC hassle. If you've got any questions, don't hesitate to drop them in the comments. I've got your back. Before you go, Make sure to hit that subscribe button so you never miss out on our legal insights. And of course, throw a like our way if you found this valuable. Your support means the world. Stay legal. Until next time, peace out.